Over the years, the myriad of challenges facing Nigeria prison system have been identified as part of the factors undermining its effectiveness in crime deterrence and correctional efforts. At the center of these challenges, which include infrastructure decay, poor financing of prison service, prison congestion, there is a strong indication that the custodial punishment of imprisonment of offenders is old-fashioned and inimical to justice development in our country because the system was retributive rather than rehabilitated.
In the past, under the Prisons Act, Capital 9, LFN 2004, the essence of penal system was punishment. It was retributive justice system, in the sense that it tends to punish the offender for the offense he or she has committed.
Apparently, the state of Nigerian justice system gave a lot of concern and has triggered stakeholders in criminal justice sector, in community development advocacies and non-governmental organization towards the need for a punitive scheme that is reformatory and is potent to guide against the perennial problems of prison congestion and endless awaiting trial incarceration in Nigeria.
The problem of prison congestion is an intractable one. It has been observed that if you look at the inmates of our custodial centers, you find more people who are awaiting trial persons. And also under the constitutional arrangement we have now, the federal government showed us the responsibilities for custodial centers. So you find a situation where states create offenses, but they don't have a place. They are not constitutionally mandated to create a place to accommodate those offenders.
Before the law was passed into, act was passed into law, we had congestion in our correctional facility. But with the new correctional act, I can tell you that the level of congestion in the facility has actually reduced to the barest minimum.
Foremost among non-governmental organizations at the vanguard of search for a novel idea in justice procedure is the Justice Development and Peace Commission, JDPC Ibadan, a non-governmental faith-based prison intervention organization and key promoter of the community service scheme as an undisputable alternative to imprisonment of minor offenders.
From the name, Justice Development and Peace Commission, and it's a non-governmental organization, it's a non-profit organization that is owned by the Catholic Church to help build the community and to make lives of people better, to give equality to people, and to cater for the development of humans in general. And it's not restricted to a particular religion. Everybody benefits from JDPC, whether you're a Christian or you're Muslim, whether you're Catholic or non-Catholic. So that's what it's about. And we are able to achieve this through different programs that we have, because we also have to look at different areas of our lives. We have the democracy and human rights program, we have the community service program, we have the Caritas, that look after the prison welfare. We have democracy, human rights, looking after the election monitoring, legal aid services, just to help in whatever way we can to do the things the government should be doing, and they are probably not seeing it from the perspective we are seeing it from, or they are not, the funds are not available, or they just don't know. So we come in our own little way to help and support and build the community, so to speak.
I had been working in the justice sector for well over 20 years now, and just before the project started in 2011, having been working, providing legal aid services to indigent awaiting trial persons in Agodi prison, then now custodian center, we observed the congestion over the years and the fact that majority of persons awaiting trial are actually persons facing charges that are capital in nature, very serious offenses. And then you have the other category of persons who have committed minor offenses but are also awaiting trial in custody, even though primarily their charges are bailable, but for one reason or the other, they are still in custody and also contributing to the congestion. So we had to think outside the box, coupled with the reality of the slow criminal justice system that we have in Oyo State and Nigeria as a whole.
Looking at it from the global perspective, the concept of the community service scheme is premised on human rights standards and norms of the United Nations, UN. These instruments of the UN include the Universal Declaration of Human Rights, International Covenant on Economic, Social and Cultural Rights, International Covenant on Civil and Political Rights, the Convention Against Torture and other cruel, inhuman or degrading treatment or punishment, Basic Principles of the Treatment of Prisoners. In addition to the instrument of the UN, the Nigerian National Assembly in January 2008 started a deliberation on a bill changing Nigeria Prison Service to Nigeria Correctional Service. This development invariably led to structural change that permitted concepts like non-custodial faculty, parole, probation, and community services in our judicial system.
To send someone to custodial center, the upkeep of that person is the responsibility of the state. You are not even sure that the person will be reformed, because reformation is part of the policies, one of the principles that underlie punishment in criminal law.
The concern of JDPC became unparalleled and the need to formulate a scheme that will circumspect the problems of dilapidated prison structures and weak supervision of inmates by prison officers who are apparently outnumbered and overwhelmed. Hence, within the period of waiting for Mr. President's consent to the National Assembly's bill, JDPC had started to consult, advocate, engage policymakers on the need for a better offense punishment initiative.
When these the need to change or to reform the civil procedure law in order to expand its scope became necessary, there were some innovations that were thought to be brought into it. So that is when people started proposing this concept of community service. And JDPC was equally one of those that effectively participated and presented the proposal to us.
In every community, you always have offenders who should be, punished appropriately. And sometimes you expect these offenders to come out better after serving their time in the prisons. But you find out that it may not be the case all the time. And we have been involved in prison apostolate, prison welfare since the inception of the organization JDPC. And we found out that the prisons are usually overcrowded, overpopulated. A prison that is meant to cater for about 300, 400 offenders, having about 1,000 offenders, we begin to wonder why. So this led to the JDPC thinking ahead and say, okay, why put so many offenders together when they have people committing minor offenses can be given community service?
To ensure that no stone was left unturned, a group of experts was constituted to form an advocacy team. Its members include reputable scholars, researchers, civil society advocates, community leaders, legal practitioners, and other stakeholders who were given the mandate to consult widely, understudy the prison conditions in the state, and formulate an innovative approach that can help justice dispensation.
There was an advocacy team. There was a steering committee to inaugurate an advocacy team, a 21-member advocacy team. That was in 2012. And those advocacy members were taken from all spheres of life, and they did a marvelous job.
Originally, both JDPC and the think tank team to Midwife Community Service Scheme were aware there was no existing law supporting the creation of the scheme. Consequently, they embarked on drafting a bill in that regard. Subsequently, the drafted bill was presented to the Oyo State House of Assembly, having the name Community Service as an alternative punishment to imprisonment for minor or simple offences.
Simple offences are those kind of offences that are less, the punishments, the imprisonment will be less than 3 years. For instance, breach of peace. When a defendant is convicted, you could consider giving such a person a community service to do. And then there are some minor stealing, let me put it in quotes, wherein an offender steals something maybe less than 1,000 naira. The punishment for stealing is 7 years. But a magistrate or a president can use his discretion to give such a person a lesser punishment.
Remarkably, the then governor of Oyo State, Senator Abiola Ajimobi, signed the bill to a state law in 2016 for proper implementation of the community service scheme in 2017.
If there are areas that I would remember with nostalgia, I would say it's our partnership with JDPC to bring that community service law into existence. As you know, things work for good with God. When I was chairman of the bar in 2012, I was privileged to have been a part of the JDPC think tank when the issue of community service as an alternative to custodial sentencing was being discussed. And I remember there was a team that put together a draft bill with JDPC then. And JDPC was running with it. We had meetings with the then House of Assembly committee on law and something, and they were pushing for its passing, but it didn't move because at that time maybe it just didn't meet the priority of the legislative house. I did not know I was ever going to be Attorney General, and then fast forward about 3 years after, I left as chairman in 2014. And I became Attorney General in 2016. So about 2 years after, I found myself in the seats and then discovered that this bill that I was a part of with JDPC had still not been passed. And JDPC kickstarted the process again, and of course, having been part of its origins, it was only natural for me to be interested in seeing it through, that this baby is not still bathed again. And I think we must give commendation to the then Speaker of the House of blessed memory, Honorable Adeyemo, who took it upon himself, being a lawyer also, to ensure that all the red tapes that would ordinarily have gone into the process were removed and created a pathway to justifiably present the bill. And I think that helped a lot with all the advocacy of JDPC to ensure that the community service bill was eventually passed in Oyo State.
It is important to underline that JDPC was very proactive in its approach, that it started organizing training for correctional officers even before the bill was signed into law. Upon the enactment of the law thereafter, they designed an operational modality in conjunction with Oyo State Judiciary to ensure the smooth running of the scheme.
So we felt that now that the bill has been passed into law, after a long stretch of time, after waiting for so long, we were trying to focus on what next, what else can we do? And you know, it's like having a baby. You can't just give birth to a baby and think that, okay, the baby will just nurture itself and build itself and grow itself on its own. So we felt that we should do a follow-up and monitor the implementation of the community service law in Oyo State. So with the help of the Honorable Chief Judge, Honorable Justice Emmanuel Abimbola, they inaugurated and created a new department entirely for community service shortly before the bill was signed, and they've already started practicing community service. Some of the magistrates have already started sentencing offenders to community service. So they employed new members of staff entirely. They employed new people and they were trained on what community service is about, and the governor was the one that he commissioned that unit, and the unit has its headquarters at the High Court of Oyo State. They also created 9 units across the state. In each of these units, there's a community service officer and a field officer.
I work with High Court of Justice. I'm a community service officer. I head the department which covers Kishi, Igbo, Shaki, Tede, Aguare. I think that's 5.
As a community service officer, my role is to accept an offender from the court. My role is to confirm if the offender is eligible for community service by making sure that such offender has a guarantor to stand for him. Then after that, I will fill the biodata of the offender and of the guarantor, and also ensuring, telling the guarantor that he should make sure that the offender is always present at the court. Then after that, I will hand over the offender to the field officer, who will take the offender to the field every day for his daily activities.
According to the interpretation of the law, community service scheme means non-custodial punishment, by which after an offender has been convicted, the court rules or sentences him to serve the community and physical work rather than undergoing imprisonment. This concept is a form of supervised non-custodial sentencing to menial jobs like cutting grasses or clearing weeds, sweeping the community to make it clean rather than years of awaiting trials, and the eventual imprisonment that indiscriminately worsens the burden of justice and makes deterrence impossible.
Community service, in a nutshell, is an alternative to imprisonment. It comes up after an offender has been convicted for a simple offense. It is a non-custodial order, which means that the offender will serve for a certain number of hours per day and then gets to go home, to come back again the next day and on to serve a sentence there.
It is worthy to note that Oyo State is the first state in Nigeria to create a separate law absolutely meant for community service scheme under the state judiciary. This feat once again accentuates the pace-setter position of Oyo among other Nigerian states. History recalls that Oyo State has the first television station in Africa, the first Olympic stadium, the first skyscraper, the first university, and its teaching hospital in Nigeria. Community service scheme undoubtedly represents a turning point in the annals of Oyo State's judicial history.
Community service sentence cannot exceed 6 months, and any offender has the opportunity to serve community service twice there. We have, currently in Oyo State, we have both High Court judges magistrates, and even President's Customary Court Grade A, who are also lawyers, sentencing convicts to community service.
The beauty of community service scheme is that it allows judges to use their discretion and apply psychosociological weapons within the scheme to achieve crime deterrence in the most convenient way.
The summary of it is that it gives the judicial officer the option of, rather than sentencing somebody to 2 years imprisonment for stealing a goat in the market or stealing a phone, he can sentence to X number of hours of community service. Now, what kind of service will then be dependent on the community service unit? And in most cases, when you look at the nature of what the individual was charged with and sentenced for, they try to position that individual in a setting that will make that community service a deterrent for repeat offense. So if somebody, like I read of one recently, of somebody who went to create a scene in a school and for whatever unjustifiable reason assaulted some individuals, and when the fellow was charged, was sentenced to observe community service in the same school where he caused the commotion. So that humbles you. If it was your child's school that you caused the commotion, you are sentenced to community service in that place, it will humble you enough to know that, hey, this is how reasonable and responsible people behave in society. They don't come and start creating a ruckus in a child's school just because you feel you can. So I like the fact that it can even be a better deterrent than imprisonment if it is properly applied in the various cases where it's used.
As the non-custodial community service sentence is gaining acceptance in many parts of the world, scholars have pointed out its numerous advantages over imprisonment. The first advantage talks about poverty inflicted by imprisonment, which highlights the severe financial effect the imprisonment of a breadwinner has on the family members. Another advantage is public health consequences of imprisonment, which explains how diseases are easily transmissible from a prisoner with existing health challenges to other inmates. There is also an argument on detrimental social impact, which shows how imprisonment disrupts relationships and weakens social cohesion when a member is imprisoned. The cost of imprisonment is also a factor. Prisoners' feeding and upkeep, as well as other indirect costs, have long-term effects on the society. Another good side to community service scheme is that it has greatly minimized the level of negative influence hardened criminals have on new offenders, who most times are inexperienced and consequently are introduced to advanced crimes.
Somebody who fought, for instance, or who argued, or who stole a chicken, or who stole bread out of hunger, you put him in a prison with a serial killer. You may not get the same results at the end of their time. And someone with such minor offenses could even come out become a hardened criminal because he has mixed with all kinds of people.
There was a time I had a case. Somebody broke into a shop, stole bread and 7-Up, and then some cups of rice. They brought him to my court. But at that time, we didn't have community service well in place. So when the person came, I was like, this must be hunger. I mean, a crime is a crime, and when there is a punishment for stealing, and then you wouldn't want that person to do that again. You would want a deterrence for that kind of person. So for me, it won't be like, go and sin no more, but for you to know that what you have done is bad, but we are looking at it from another angle so that you won't just go to prison, you won't go we won't send you to the correctional services center for this reason and this reason. Go and serve community service. We will sentence you to community service for like probably some days, some months, depending on the discretion of the magistrates that sits on that kind of matter.
The outstanding success recorded by community service since it was inaugurated in Oyo State is highly encouraging. Between January 2018 and April 2023, almost 1,000 minor crime offenders who would have languished in prisons have been sentenced to community services across all the magisterial districts in the state. Thankfully, only a few cases of recidivism is recorded.
The gain has been enormous. For one, and even if for nothing else, the very fact that there's a law in Oyo State, a separate law on community service function, and it's actually the first in Nigeria. The Lagos State has community service too, but a law that is standing alone, Community Service Punishment Law of Oyo State 2016. And then the very fact that we are able to prevent certain persons from going into the custodial center, then prison. And it's also giving the criminal justice system in Oyo State a human face. That look, it's not just about punishment, it's also about reform.
The bar receives it with open arms because we go to prisons, we are exposed to what prisoners and inmates go through. We know as a fact that government does not have maybe sufficient fund for our custodial center. So if the human person is at the center of development, once we can achieve reformation of that person through any other scheme, and community service is a viable option, we embrace it.
The success of the community service scheme in Oyo State should not be a surprise to anyone who is familiar with our story as a people. Historically, the Yoruba people are community inclined. Every development strategy that is not community initiated, community driven and focused is not likely to generate any enduring impact.
Community service has been on from ages during the olden. Actually, let's talk about the Yoruba tribe. Community service has been there since. Whenever there is a petty crime during those days, the offender will have to serve the community. So more or less, the concept of community service was given back to from the belief that an offense to one member of the community is an offense to the whole community. So the punishment also should be in such a way that it will correspond to the offense given, and the community as well will benefit from the punishment as well.
Now, nísìnyí táwa ti fi òfin gbé lẹ́sẹ̀ láti máa ṣe community service, a rí pé ó rí ẹsẹ̀ wà lẹ́jú táyé ìjọ́un lọ. Torí nígbà yẹn kò sófin, wọ́n á parọ́ mẹ́lòmíì tí wọ́n bá ti rẹ́lẹ́rìí èké takò ó parí nìyẹn. But nísìnyí wọ́n á ṣèwádìí ẹ̀ fínífíní kí wọ́n tó lè sọ pé ẹni yé tó tọ́ a convict ẹ̀. Okay, kọ́ lọ jẹsẹ̀ rí àbáyé. Now, ìyàtọ̀ tó kọ́ wà ń bẹ nìyẹn. Ẹlẹ́ẹ̀kejì ni pé nígbà yẹn lọ́hùn bí a kàn gbé sí gbàgede ìlú lásán sọ ni ó parí náà nìyẹn. But láyé sí tó bá commit offense ní àdúgbò kan, wọ́n á mú lọ sí àdúgbò yẹn. That very community mẹ́rin tó lọ serve punishment yẹ. Ta ẹni tó jẹ́ ewúrẹ́ wa gbé náà nìyí. Okay, ewúrẹ́ wa tó jí gbé. Òun ló mú tó fi ń sán oko níbí báyìí. Ẹ wá rí pé nígbà wọn lè pé kẹ́lómi lọ roko ọba. Nísìn ṣèjọba lóko kan ni. Wọ́n lè mú lọ sí school.
Like every development initiative, the community service scheme is not without its own inherent challenges, which include some form of unwillingness from the public to serve as guarantors to offenders and a few cases of criminals that absconded.
And because community service is non-custodial in nature, meaning that the person comes from his or her house and reports and then goes back to his or her house, we have to ensure that the person has guarantors, at least a guarantor that would be able to control the person and be sure that the person reports to the center every day or where the sentence is supposed to be carried out. Then the guarantor also should be someone that would be able to give us regular feedbacks on the person. Apart from the person's duty here, we want to be sure that the person is actually remorseful in his or her own environment. So we ask for regular feedback from the guarantor also. Then peradventure the person doesn't come for one or two things, maybe the person is sick or something, it's the guarantor that we report to, and the person will now come and give back feedback. And finally, in case an offender absconds, it's the guarantor that would bear the consequences of the offense.
The major challenge is the issue of guarantors, actually, because if you give community service to an offender, probably for like 1 month, that person needs to have a guarantor who stands for him and make sure he serves that term of community service. But in a situation where the offender comes and says he doesn't have anybody to stand as guarantor to him, somebody that ought to spend like 1 month for community service, you may not have an option than to just tell the person to spend like hours, like 3 hours of community service and let the person go.
I sentence an offender to 3 weeks community service. At the approach of the second week, he went away. We didn't see him. So I had to tell his guarantor, who happens to be his father, that there's a criminal implication for it, that they should go and look for him. So it took about 3 weeks before seeing him.
The scheme also has a challenge of funding. In this regard, development experts and legal practitioners have solicited the support of the federal government.
The major challenge to me is just the paucity of funds. Community service scheme needs serious funding from the government, and I like to acknowledge the efforts of JDPC so far. We've been having series of lectures, series of training, series of feedbacks through their efforts. However, government really needs to look into the community service scheme and fund it. They need a lot of funding for them to carry out a lot of things that they need to do.
We hope the government will take over it and then put more money to the funding of the community service scheme. It will go a long way. It will help the society, and it's a way of reducing, if not totally eradicating, crimes in the society.
So far, with the little efforts that we have been able to put into the scheme right now, we have achieved a lot with the little effort. So if the government can really look into it, take over the scheme, and then make it what we really need to see come out of it, I think it's something that it's worthy of being really, really attended to, given serious attention.
The wide acceptance of the community service scheme is not limited to legal practitioners and community leaders alone.
The first day that I came here, I find myself like I'm not happy. But when I mix up with my colleagues, we talk together, we advise each other that let's go back. When we are done with this community service of a thing, let's look for a job. There are different types of jobs that we can go into with legit way without frauding someone. And since then, I've been into POS business, which I've been doing since last year, and I'm making a little profit to sustain myself.
For the time I've been here, they have been very friendly with us, both the officers on the field and the one at the office. They have been very friendly with us. Every day they will ask about our family. Even if they notice anything about us, they ask questions. They ask questions a lot.
I'll employ the young ones not to engage into any fraudulent act, any crime, any illegal act at all, be it social, be it on the internet. They should not envy their friends when they see them doing other things. They should just stick to their ways. They should go to school and hopefully get a job and everything will be okay.
Obviously, for community service scheme to adequately fulfill its restorative objective, the necessity of counseling cannot be downplayed.
Said was among those offenders posted to Iyagoku. From Iyagoku, he has also been reposted to Ring Road. At my first encounter with Said, he was to serve 6 months or thereabout or less than that. At my first encounter, I could see his unreadiness, unwillingness to change. There was evidence of a reckless life. He had smoked and he was still smoking, and he was still sounding. He hadn't met the reality of the situation. By the time we visited him the 3rd time, I could see a true picture of a modified behavior, to the extent that I had to call the elder brother who sells something at Aleshiloye, and he testified that since serving the community service and coming to serve, that he has truly changed, to the extent that things he was not doing in the past, he was now gladly doing it. He come to the shop, he stayed with him, he opened the shops. And there's another particular client that is an elderly person. He said he was convicted because he had to destroy things of his tenant and so on. And this particular tenant is a landlord. He locked the door and did all the demolition. In the course of our counseling, he volunteered that he was going to organize a program in his community on discharge. That he has now seen that truly you do not need to take laws into your hand, that you have to be systematic about whatever you do.
The law states that a person cannot serve community service more than twice. So if at the first instance, if a person was sentenced to community service for a minor offense, he comes back a 2nd time, he's sentenced to community service. Once he comes back a 3rd time, he's going to prison. But so far, we've noticed that of all these 586 people that have been sentenced to community service, I think just 2 have come back. So we can say that some community service is quite successful in the sense that it has reduced the rates of recidivism among offenders who have undergone the scheme, who have passed through the scheme. It is actually reforming these offenders.
As stakeholders commend and prescribe the scheme for other states in Nigeria, words of commendation and appreciation were directed towards JDPC, the author, the initiator of Community Service Scheme, for its ingenuity and doggedness.
I want to appreciate JDPC for initiating this program. We, as a counseling psychologist, we have the broad spectrum of knowledge in behavior change, and that is our main work and duty as a counseling psychologist. So when the idea of community service came from JDPC, we looked critically at it and we felt, well, this is part and parcel of our work, and we'll be really interested in the people in the correctional homes, because human behavior is learned and could be unlearned. Various factors are responsible for people behaving the way they want to behave at any particular point in time. And we strongly believe that when all these factors are looked into, the essence of people going to correctional homes, formerly prisons, will be reduced minimally.
JDPC have done wonderfully. When we came on board, they welcome us with full hand, and we are working in synergy with them. If you can even go to the judiciary will praise the JDPC in their efforts on community service in Oyo State.
Without JDPC, I doubt if we would ever have had community service as a scheme in Oyo State, or even as a scheme in any state of the Federation.
I make bold to say that Oyo State is taking the lead amongst the states that are, utilizing this non-custodial alternative, and I'm imploring other states too. They should also emulate this scheme, and it's a very great alternative to custodial sentencing.
No doubt, the community service scheme is novel and innovative. Offenders are punished, yet their dignities are preserved. We can only hope that other sectors of the society would learn and pick intervention programs that best suit our culture and tradition so that we can make meaningful progress across board. Long live JDPC, long live Oyo State, the pace-setter state.
The success story recorded already in Ibadan is already a platform for others to build on. So in whatever way JDPC Ibadan can be of help, we will not shy away to make our input felt so that other states also can benefit from this community service that has already recorded huge success in Ibadan JDPC.